All right, welcome back, everybody. Right now, we're going to move into Chapter 4. Chapter 4 is going to be our medical, legal, and ethical issues. So this one can be a little bit dry, but it's really, really important stuff for us to think about while we're starting our journey as emergency medical responders. Got here just the same national EMS education standard that we've had in the other slides. Some of the things that we're going to be going over in this chapter is consent and refusals, confidentiality, advanced directives, which is like the things that patients want to have happen. They can go in and talk with a physician prior to anything happening and make a list of things and care that they would want if they were incapacitated. Tort and criminal actions, evidence preservation, statutory responsibilities, mandatory reporting, ethical principles, and some end-of-life issues. So it's important to know that laws differ from state to state, if you didn't know that, right? And even from jurisdiction to jurisdiction within some states. So EMRs are responsible for knowing and learning the specific laws that apply to them in their local jurisdiction. All of these, though, are going to be centered around the idea of do no harm, provide good care and good faith, and then provide proper, consistent care, being compassionate and maintaining composure. So despite whatever the local laws may be, those three things are most important. So the first thing we're going to talk about is duty to act. Now, a duty to act specifically means if you are working for an EMS agency, any other public safety entity, police, fire, whatever it is, once you get a dispatch to a scene, you have a duty to act. And at that point, you must proceed quickly to the scene and provide care to the best of your capabilities. What this doesn't mean is if you're driving along in your personal vehicle and you see an accident, you have to stop. So that is not a duty to act. You only have a duty to act if you are in an official capacity at the time. Failure to respond and render care appropriately could leave you or your agency vulnerable for legal action. So that's the most important part of duty to act. Once the tones drop, once that pager goes off, you need to get up, move with a purpose, and go respond to that emergency. Standards of care is how we provide the care that we are giving. So you must treat patients to the best of your ability the same way every time. And you have to provide care that any other reasonable person in your shoes would do. So if another EMR showed up on scene, would they treat the patient the same way that you just did? The scope of care is defined by the U.S. Department of Transportation. And this is in the Emergency Medical Responder Education Standards. So right now you're going through the class, you're going to learn the standards of care, the scope of care, and then that is what you're going to be held to. The other part of that is whatever your local medical director tells you. So just because you're learning a scope of care now in this class doesn't specifically mean that your medical director is going to allow you to do all of the things that you learn in this class. They may limit it a little bit more. And then once you're there in the heat of the moment on scene, to go along with whatever you've learned in class, whatever your medical director has told you, if you have further questions, that's when you're going to reach out to your online medical control and however that works in your jurisdiction, whether it's reaching out to the local hospital or calling your medical director directly. Ethical responsibilities, we've mentioned this in some of the other chapters already, but making sure we treat patients ethically means that we're staying up to date on our skills, means that we're reviewing our performance. So after every call, we should think about what did I do? How can I do better? And how can I improve my practice based on what we just did? Evaluating our response times, looking at that and saying, based on the standard, once that dispatch call came in, did I respond in a timely manner and the time that my agency is expecting me to respond in? Then it's important to try and follow up as best as we can. Some people like to follow up on patient outcomes more than others, but it is good quality improvement to just know if whatever you did on scene, if it actually made a difference. And you can find that out by following up on patient care outcomes after they've been released from the hospital or after they've spent time in an in-facility part of the hospital. Then it's important to stay up on continuing education, just making sure that you're refreshing constantly, keeping this fresh in the back of your mind. Especially in the EMR world, sometimes you're not going to be responding to medical emergencies all the time. If you're police or fire or search and rescue or some type of other specialty team, maybe this isn't what you're doing all day, every day. And so just making sure that it's something that you think about enough that when it does happen and when you do need to provide medical care, that it's there and it's fresh and you're good to go. Always be honest. When other EMS providers arrive on scene, whenever maybe you're transporting somebody to the hospital, whatever the case may be, provide a complete and accurate account of what you did to those other providers. Once again, this goes back to, we mentioned a little bit about documentation in another chapter, and just making sure that that continuation of care can happen because of you giving a complete and honest account. And then never change a report except to correct for an error. And it's important when you're correcting your documentation, if you do need to change something, some EMS charting systems will actually keep track of all of those changes that you're making. So they'll be able to go in on the backside and look and see that you made a change. So it's important to just note like that you did make a change and why you made that change. So consent for treatment. This is an important one in all that we do. It simply means that the patient is giving you permission to treat or transport them. Just because somebody calls 911 doesn't mean that they want you to go up and touch them and start treating them right away. It may be that somebody else called 911 for them. And in that case, they may not even want you to be there. So making sure that they have given you permission to treat them. So expressed consent means the patient actually lets you know, yes, I want you to treat me. No, I do not want you to treat me. So direct verbal communication there. Some people call this actual consent or however they want to describe that. But the important part of that is that the patient must be of legal age and able to make rational decisions on their own. There is some gray areas, and once again, this is why it's so important to know your local regulations, because you could have emancipated minors. In some states, if a female is pregnant and above 15, then they can make their own decisions. And the laws really differ by state. So it's important for you to know what the regulations are in your state and what it says for minors and how they are able to consent. But just make sure that they're of legal age. And then the other part of that is that they're able to make a rational decision. And we'll go into a little bit more in detail as we go through this. But that means making sure that they don't have a medical injury or medical condition or an injury that is preventing them from thinking clearly. So implied consent simply means the patient does not specifically refuse to your care. And it would be in the case of if you showed up on scene and it was a traumatic scene and somebody is unconscious, then you are able to say, it is under my assumption that any reasonable person would want me to treat them at this time. Same thing if it's a medical emergency and they're unconscious. Any reasonable person would want me to treat them at this time. So they're not specifically giving you that direct consent and saying, yes, please treat me because they're unconscious. But what we're doing there is we're saying, hey, I would assume that they want me to treat them. And then consent for minors, we touched on this a little bit. We need to know what the laws in our state actually say about whether or not a minor can consent. If there's no adult there, then we just need to treat them. And then sometimes if they're at school or something like that, maybe there is an adult that is responsible for them at that time. And so you just need to do the best that you can with that. I've had situations where we go to a school because we got called there by the teacher, and we start treating the kid because we haven't been able to get a hold of the parent. And then the parent shows up and says, hey, I don't want my kid to be treated for this. I want to take him myself. I want to do whatever it is. And then we just have to allow that to happen. But use your common sense, use good judgment, and know the laws around what a minor can and can't do in your state. Emergency treatment must wait until a parent or legal guardian consents for treatment. If permission cannot be quickly obtained, don't hesitate to give appropriate treatment. So once again, this would be that case where you get called, there's a kid that's been sick or injured. If it can wait, then wait, try and call a parent, get permission. If it can't wait, then you just start treating as soon as you can. Consent for patients with mental illness. If the person appears to be a threat to themselves or others, then you can place them under medical care. Some states are going to require law enforcement to get involved in this, and there's, once again, different regulations when it comes to that. But you need to protect yourself and you need to protect others. So if they are a danger, then you need to take whatever steps are necessary. But once again, don't hesitate at any time. If there is a threat perceived, get additional resources coming, get the help that you need to protect yourself and everybody else around you. Patient refusals. For a long time in my career, I learned that this is like one of the most important things to document as to why they wanted to refuse and who is allowed to refuse and who isn't. So we're just going to spend a little bit of time talking here about some of these. So a competent adult has the right to refuse treatment, period. So trying to figure out if they're impaired or if they are competent becomes really important for us. But if they're having a heart attack in front of you and they're competent, they're alert, they know what's going on, but they don't want treatment, they have that right. And it's a protected right. We can't take it away from them. To actually go and start treating them is actually battery. So once again, like it's difficult for us as responders, as people who want to go and help, to have to step back and be like, no, they said no. I can't force them to accept my treatment. But what is important is that they have to know the dangers of refusing that treatment. So you need to be able to explain to them the reason for the treatment and the suggestions that you have. You need to very clearly explain to them the potential risks, including life-threatening risks, if they refuse the treatment, and then alternatives that they have. If they don't want help from you, you need to be able to explain, all right, you can take yourself to a hospital, you can still reach out to your doctor or a clinic, or you can always call us back. If you don't want us here right now, this moment, treating you, that doesn't mean that in an hour you haven't changed your mind and now you do want help. So make sure that they understand those parts of a refusal. Patient refusals should be documented in your patient care report. Um, and how that's going to be documented is going to be specific to your agency. But just making sure that when you're in that documentation, that you're very clear about this is what I told them. These are the risks associated with whatever their injury is that I informed them of. If you called your medical director to try and get them involved, put that in there. Whatever steps you took to try and convince them to go, make sure you write that in that patient care document, and everything is documented properly, and that you have signatures from them that say, I know the risk and I'm choosing to stay here on my own. Advance directives are a document that specifies what the patient would like done if they become unable to make their own decisions. And so a lot of times these will be something like a living will. And this is where the patient has sat down with a physician and a lawyer, and they say, hey, this is what I want to happen. If my heart stops, I want these steps to be taken. I don't want these steps to be taken. Um, and how that is documented, once again, I know this is kind of the annoying part about medicine, but once again, it all depends on the state. There's not really a whole lot of national standards around how they have those living wills or do not resuscitate orders or whatever it may not be documented. So knowing how that is in your state is the most important thing. We have durable powers of attorney for healthcare. So a power of attorney is you giving somebody else the ability to make decisions on your behalf. And so with this, it allows a another person to make healthcare decisions for you. And there's a couple of different types of power of attorney for healthcare that you can have. There's one kind that as soon as it's signed, then that person now has the right to make decisions for you forever. And that could be somebody maybe with, you know, your grandma has dementia, and so there's a signed power of attorney now that says that this family member is going to make all of their decisions because they're incapable of making those decisions for themselves. The other kind could be as soon as I am incapacitated, if I am unconscious, then I'm giving this permission or this person permission to make decisions for me. But as long as I am awake, conscious, and able to make decisions, then I have power of like my own healthcare, and they don't have that power of attorney over me. So there's different types. And so if somebody says I have power of attorney, then you need to make sure that you see that documentation and know what kind of power of attorney they're talking about. Do not resuscitate orders, I mentioned a little bit briefly already. So this is a written request to not do any life-saving resuscitative measures in the event of a cardiac arrest. So we're not doing CPR, we're not going to be doing breaths for them, we're not giving them medications. But once again, there's a caveat with this, and each type of DNR could be different. It could be, I don't want compressions, but you can go ahead and breathe for me. Or I want you to do compressions and breathe for me, but I don't want any medications. So once again, if somebody says they have a DNR, then we need to actually see that document and know exactly what their wishes were. So for most of these, there's different forms, like I said, for each state. But one of them that you'll see is the POLST or the MOLST. If you're unable to determine if there are advance directives, if they're legal, if they're valid, whatever the case may be, you just go ahead and treat them. Some states will have bracelets or different ways to identify people that have those advance directives. It's not uncommon to show up on scene and have a family member saying, oh, they have a DNR, but I don't know where it is. If they can't produce that document, then you need to go ahead and just treat as you would without that. So in the case of a DNR, if you show up on scene to a cardiac arrest and they say we have a DNR, but they don't have it, then you go ahead and start doing compressions and breathing and medications and everything that you would normally. So it can get kind of touchy and families can get upset, which goes back to that ability that we require our EMS providers to be able to handle family members and bystanders on scene. And I always tell patients as we're going to them and they're sick, or if they say they have a DNR, I ask where it is. I make sure that it's in a general location so that family knows, whether that's above a bed in their room, next to the front door, in a medicine cabinet, so that whenever you show up, you can find those things. And those are actually some locations that I recommend you look as well if you show up on scene and they're saying they have a DNR, or if you show up and there's nobody there and you may suspect that they have a DNR. And there's a couple of locations like that: bed, the front door, the medicine cabinet, the bathroom, some places where you could look to see if maybe they do have something like that. Abandonment's really important for us. In once we show up on scene, we cannot leave that patient. And so abandonment occurs if you as an EMR show up on scene and start treating that patient and then leave without either another EMR or a higher level of care showing up and taking over patient care on that patient. So once you have started care, you have to continue until somebody else arrives to take over that care. And then it also works in the fact of, if a paramedic shows up on scene and starts treating that patient, they can't leave that patient and leave them in your care at that point. Once they have taken care, then they need to be able to continue that care. People dead at scene. So this is going to happen where you're going to get called and you're going to show up, and it's going to be a situation where there's an obvious death. If there's a decapitation, tissue decomposition, so they have things on here called rigor mortis, which I'm sure most people have heard about. It's just as those muscles tighten up after death, they become really stiff, hard to move. And then dependent lividity. So this is going to be if somebody's laying on the floor and you'll see like red marks along their back from where the blood has pooled because gravity has settled all the blood out of their tissues and out of the blood vessels, and now it's settled in a location. So if they're on their side or their back or wherever it may be, you'll start to see kind of the blood pooling in their body. If you see some of these things, then you can assume that that person is dead, and that treating them, doing CPR, or anything like that is going to be a futile attempt. There are different rules and regulations around whether or not you need to start CPR and treating those people. But for the most part, if you see these things, then you can safely assume that they're dead on scene and contact your medical director. If they have any of these signs that we talked about, you can presume that they're dead. But it is important to know your local guidelines and know what your medical director wants you to do in those cases. Sometimes it may be that you need to start CPR until somebody gets there, that can do a little bit more extensive of an assessment on them, hook them up to heart monitors or different things to be able to determine that. But once again, I know, cop out, and you're going to hear it a lot, but it's really important to know your local guidelines. Local guidelines dictate everything that we do. Negligence. Hopefully we don't see a whole lot of this in our careers, but negligence occurs when a patient sustains further injury or harm because of what we did. So there must be 4 things in order for them to be able to prove that there was negligence. So we have to have had a duty to act. So you need to be in a status of working for an agency where you got a dispatch and you got called to the scene to go and treat them. There needs to be a breach of duty that results in injury, and then approximate causes. And we'll go over some of those here. Most patient information is confidential. So if you haven't heard of HIPAA laws, you'll become quite familiar with them. But this is the laws regulating patient information and how we share that among healthcare providers. So information that we can't share is patient history, any of our assessment findings, what treatments we provided, and our communications that we've had with the patient. So anything that we've gathered in those different areas can be shared with other medical providers and people directly involved in their care, I guess I should say, but not outside of that. So if you go and you treat somebody and then your friend comes on shift and they say, hey, did you go to that call with Jimmy? Well, you can't answer that. You can't give them details because they're not related directly to the patient care, and you're sharing somebody else's protected health information at that point. So there are times where you're able to release some of that information about their healthcare to other individuals. Law enforcement may get involved, your supervisors, different people, and they're going to help you understand the regulations around all of that. But all of it is protected, like I said, by these HIPAA laws, which is the Health Insurance Portability and Accountability Act. So Good Samaritan laws, like I said, we have a duty to act if we're in a status of actually working for an agency. But if we're not, then normally we'll be protected by Good Samaritan laws. So Good Samaritan laws protect citizens from liability from errors or omissions in giving good faith healthcare and first aid to people when we come across them. Once again, it really varies by state as to how those laws are going to be in place, how they're going to affect healthcare providers. So it's important to know, once again, what those laws are in your state. But what I would say is EMS providers, you have this information, you have this knowledge now, and you need to be very careful about using those skills and those treatments when you're not in a duty to act situation. If you're not actually on duty, if you're not protected that way, your medical director may not allow you to do anything if you're not on duty. And so then that could get in the way of Good Samaritan laws. So it's important that we become familiar with our state laws. As I've said many, many times in this slide, in this chapter already, it's all going to depend on the local laws, local jurisdictions, and what your certification may be. So just become familiar with those things. So there are some reportable events for us in healthcare and in EMS. There are certain things that we have to go to law enforcement, or we need to tell the hospital so that they can tell law enforcement. And those things generally are going to be knife wounds, gunshots, motor vehicle crashes, suspected child or elderly abuse, domestic violence, dog bites, and rape. And these are just like violent crime type things that we need to be able to monitor, and law enforcement needs to be able to get involved to protect those that may be involved. So you need to learn, once again, learn which crimes are reportable in your area and know who you need to report them to. Failure to report a reportable crime in your area could result in penalties for you or your agency. We talked about this in one of the other chapters as well. Many medical emergencies can also be a crime scene. So some things to keep in mind: protect yourself first and foremost every time. Protect yourself. If it is determined to be a crime scene and if it's unsafe, then you need to wait at a safe location before you enter. And then your first priority when you get on scene is patient care. Like we mentioned the other chapter, sometimes we're going to ask that you don't move too many things, that you don't disrupt the scene as much as possible. But your first priority should be the patient care and making sure that they're safe. And then we can figure out what happened with the crime scene as time goes on. So when you're assessing the scene, document anything that seems unusual. Normally on these type of scenes, we may not be the first one there, unless you're an EMR working for a police department, and then you might be. And then you know more about documenting the scenes that I'm going to teach you here. But just pay attention to how things are, things that might seem out of the ordinary. And as we're doing our documentation, keep note of those things. If you need to move the patient, do it only if necessary. Otherwise, wait until that can all be documented as well. Touch only what you need to touch. And then don't cut through any knife or bullet holes. So a lot of times we're going to have to expose our patients so that we can treat them and bandage them. And so if we have gunshot wounds or stab wounds, then we don't want to cut through those on our clothing to remove the clothing to expose our patient. So at that point, you'd want to be cutting along seams or some other place so that they can do all of the criminal investigation things that they do with those clothings, with those articles of clothing. Once again, be careful where you're setting equipment. You don't want to set it down on a piece of evidence. If you can avoid it, keep all non-essential people out. So if you're able to go in with a smaller crew to treat the patient, do that, keep other people out, and only have the people needed in there. Work with the law enforcement agencies that are there. Ask them what you can and can't do. If they need you to avoid certain areas, they'll let you know. And then one thing that I've tried to do is we have our patient care reports, and that's important for our patient care, but sometimes it's really important to just write down an extra little note about other things that you saw related to the incident, so that if there are questions later, you're able to refer back to those. And that's going to tie right in here to our documentation. Documentation is the initial account of what happened and what you did with that patient. Our medical documentation that we provide is an actual legal record of our treatment. And if they decide later that they want to sue over their treatment, it could be 3 years later that that's actually coming around. And now you find yourself in court, and this document that you wrote down about your patient care is what they're going to pull out. So you want to make sure that it's accurate and it's something that you would be able to read through and hopefully refresh your memory many years later. It also provides the basis for all care that is provided with that patient. Our medical records that we do pre-hospitally are added into that patient's medical records. And so they're able to go in, and if there's an orthopedic injury that happens, if they're in a car accident or something, and 2 years later, they're still in rehab for that, and the physical therapist wants to understand better how the initial injury happened, they're able to go into the patient's medical record and look at that document that you wrote as the EMR, as the first person on scene that described the scene, the mechanism of injury, how the vehicle was impacted, where the damage was, so that they can gain a better understand of the patient care. So it's a continuation of care, and one of the reasons why it is so important that we're as accurate as possible. But once again, make sure it's clear and concise. A couple of things that you should include in your documentation: condition of the patient when you found them, description of the injuries, the initial set of vitals, any treatments that you gave, any infectious disease exposure. There's a good list here. And like I said, if we're looking at the case of a car accident or something, how the vehicle was impacted, how much intrusion there was into the vehicle, was there any windshield damage, was there airbag deployment, were seat belts worn, anything like that is really important in our documentation. So we've made it to the summary portion. As an EMR, you have the duty to act if you're dispatched to a medical call as part of your official duties as a firefighter, as a police officer, as a search and rescue team member, whatever the case may be. You should understand the differences in expressed consent, implied consent, consent for minors, and all of these things are really going to come down to your local state and where you're working. And so I hate to say that we learn some of these things after the class, but we really do. A lot of that comes down to once you're in an agency and you're working with them, getting to know what those rules and regulations are. Advanced directives gives a patient the right to have care dictated by somebody else, understanding the differences in the different types of advanced directives, and then understanding the concepts of abandonment, negligence, and the Good Samaritan laws. Certain things that we go and deal with are going to be abuse or illegal acts, anything like that. Once again, know the reporting requirements in your area, know what type of events need to be reported and to whom they need to be reported. Make sure that if you do get called to a crime scene, we're paying attention to the area and we're working closely with law enforcement so that we're only disturbing the crime scene as little as possible. Know and understand that part of our job, as much as we don't like it, part of our job, and a very important part of it, is documentation and clear, concise, and complete documentation. So we'll go ahead and go into some of our review questions. Emergency medical responders have the legal duty to act only when they have been compensated by a certified agency, if they witness an emergency scene while not on duty, even when outside of their response jurisdiction, or if they are employed by an agency as an EMR. So the answer is D, if they are employed by an agency as an EMR. So remember, duty to act is only if you're at work, not if you're driving past a scene or anything like that. Patients are legally able to make a decision regarding their care if they are of legal age, according to state law, have injuries that are life-threatening, refuse transport to the hospital prior to becoming unresponsive, or have bystanders who can verify their competency. So the answer is they are of legal age according to state law. And I just want to go back and kind of talk about this one for a second. Refuse transport to the hospital prior to coming unresponsive. So this is one of those important ones. If they are competent, if you have been able to determine that they are alert, oriented, their mind is working right, and they refuse care prior to becoming unresponsive, then it's kind of a legal gray area. And I recently had a class with an EMS lawyer who talked about this. But at that point, they have refused care. And so if the example given was a cardiac arrest, if you get a call and that person is having chest pain, but somebody else called for them, somebody saw them, and they said that person doesn't look too good, and you show up and they're like, yeah, I don't feel too good, my chest kind of hurts, I've got jaw pain, and you're saying to yourself, this person is having a heart attack, but they say, I don't want to go to the hospital. My wife died 5 years ago and I've just been waiting for Jesus to call me home. And they're able to answer your questions, and then they drop dead in front of you. Like, at that point, how does that work with consent? And it's one of those things that, once again, like, I would refer to your medical director, I would refer to your local guidelines. But that's what this question is essentially asking. Like, did that initial refusal count now that they are unresponsive? EMRs have the ethical responsibility to provide care only when a paramedic is present, discuss details of each case with their coworker and families, transport all patients to the closest hospital, or conform to accepted professional standards of conduct. And that one is D, conform to accepted professional standards of conduct. All right, I know that was kind of a quick go through of some of the legal and ethical things. You guys are doing great. We're going to continue on. That was chapter 4. We're going to move on to chapter 5. You guys are doing awesome.